كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson number 3 of this juridical law, mashallah, Kitab al-Da'wa wal-Bayyinat. As you know, we've been discussing the more kind of complicated cases where there's a double claim put in, so how to give preference to one over the other. Otherwise, as you know, the simple claims where there is no competition, where there is no two people making claim for the same thing, those are much easier to deal with, right? So let's move on to a few others that we have here that Imam Quduri discusses. So وَإِنْ أَقَامَ كُلُّ so let's go back to the case of the last lesson, the last one, which is that if they both claimed and they both had different dates for their claim, then obviously the one with the earlier date would have been given the preference. Now, another case, the other case we're going to deal with today, for example, وَإِنْ أَقَامَ كُلُّ وَاحِدٍ مِنْهُمَا بَيِّنَةً عَلَى الشِّرَاءِ مِنْ آخَرٍ. Right? So, there is person A and B. They are claiming, so person A is claiming that this particular iPad, I purchased it from person C. And person B is claiming that they purchased it not from person C but person D. So now there are 4 people in this case, right? 2 claimants from 2 different individuals. They both mention a date. There's only one item though. It's not 2 different items, it's one item, right? And how do you know it's one item? Well, maybe the same serial number, or you can tell it's just one item. They're both saying, yes, this is the one, right? Now, you know, it could be understood that maybe there's 2 items, but actually no, there's only one item here. They both mention a date. Then in that case, they both have evidence. They both have a date. They're both the same. Now, the date here, interestingly, the date could be different or the same. Now, if it's the same, then obviously they're both the same. But the date could be different. One could be earlier than the other. But he's saying, فَهُمَا سَوَاءٌ. This is a bit more complicated. They're both equal in this case. We can't judge one or the other, even though one has an earlier date. Why? He says, because really what they're doing is, because there's only one item, what they're saying is that person A is saying that person C is the seller, and person B is saying that person D is the seller. So we better get that right before we find out whose it is. Is person C the seller or person D the seller? Right? That's where it gets confusing. So that gets cancelled out now. Right? It's saying فَيَصِيرَانِ كَأَنَّهُمَا أَقَامَا الْبَيِّنَ عَلَى الْمِلْكِ مِنْ غَيْرِ تَارِيخٍ. The dates will get cancelled out in this case. And it is as if they both have provided evidence that they own it. Right? That's all. That ownership of their respective sellers. All they're establishing is that guy sold it and that guy sold it. So it just shows that both of those guys are sellers. It's going to go back to being the case that we mentioned earlier, where they both have a right to take half. Half from this guy and half from this guy. So person A, if he wants, he can take half and pay half to person C, and person B can pay half to person D and take the other half. It's going to become one of those. Of course, because they didn't really want half, they didn't set out to buy half, they set out to buy the full thing. So that's why they get a choice now to take their share that they have a right over, or they leave it, just as the previous one. So this is a bit of a different case, right? Even though there's date here, but because there's 2 sources of sale, right? Here, the dates don't matter anymore because it becomes a case of who is the seller. You understand what I'm saying? It's always about establishing one particular point. Only then can you establish other points. So in this case, the point is about who is the seller. Now they both have provided evidence, so it just shows that they're both sellers. It doesn't matter about the date then, because clearly somehow they both became sellers. So it's just 50-50 that they're both sellers. Now both of these individuals who are making claims can buy half from each of their particular sellers, and they'll get the money, right? Now you might be thinking, but it may not be in any of this, right? Because it's these guys who are making the claim. no, well, it becomes theirs. It is theirs. They must have somehow. There's no way that somebody's just going to make up a claim like that. So somehow, either the first person owned it, or they were maybe partners or something like that. That's why they were two brothers. They got it in inheritance, so they bought it together. Maybe that's the case. But the case, the claim here is not about that. The claim about that is, who did I buy it from, right? So there could be so much other assumptions behind it, but because that's not part of the claim, we're not going to discuss that. All we're discussing is whatever the claim is about, which is that it's this. Okay, وَإِنْ أَقَامَ الْخَارِجُ الْبَيِّنَةَ عَلَى مِلْكٍ مُؤَرَّخٍ وَأَقَامَ صَاحِبُ الْيَدِ الْبَيِّنَةَ عَلَى مِلْكٍ أَقْدَمَ تَارِيخًا كَانَ ذُو الْيَدِ أَوْلَى. This is a case. Many of these sound similar, but we have to understand the subtle difference between them. So there are two people claiming a laptop. One person is actually holding the laptop, has it in his possession. He's claiming it, and person A is claiming it as well. So person A, person B has the laptop in their possession. They're both claiming it. They both provide evidence as well. No, actually, the evidence is provided by person A. It's a dated one, so it's 1st of February, for example. So when أقام الخارج البينة على ملك مؤرخ, he's the kharij, meaning he doesn't have it in his possession. وأقام الصاحب البينة, صاحب اليد, and the person B who has it in his possession, he also provides evidence على ملك أقدم تاريخا. Now in this case, he also provides evidence, but with a date that is 1st of January, so it's earlier than February. كان ذو اليد أولى. In this case, he becomes superior. He becomes the preferred person to take it, because if they both had no evidence, if they both had evidence, which was the case we dealt with earlier, strange case, that they both had evidence, but there was no date, then in that case, the person who had it, who possessed it, is not preferred automatically over the other person. The other person is preferred because he's establishing something new. But in this case, there's a date. Dates are very, very powerful. So he gets it because his date was earlier, not because he's got possession of it, but he provides an earlier date. The possession is besides the point in this case, right? He has an earlier date. And the way it's explained here is لأن البينة مع التاريخ متضمنة معنى الدفع, right? So I was explaining لأن البينة مع التاريخ متضمنة معنى الدفع. He explains, Imam Maydani explains, because when you've got a claim and proof, etc., along with the date, then essentially that is it incorporates an element of defense in there, defending against the evidence that the other provided. So it's strong enough in that case to take it, right? So so he's going to be more rightful of it. Imam Marghinani in his Hidayah clarifies that this is only according to Imam Abu Hanifa and Imam Yusuf, while Imam Muhammad also has a transmission favoring this point, whereas Imam Muhammad also has another transmission which shows that no, it's going to be like the original case, whereas the person with the possession is not going to be preferred in this case. But Mahbubi, Nasafi and others have actually given preference to Imam the Shaykhain, Imam Abu Hanifa and Imam Abu Yusuf's view, which is the first view. Right. وَإِنْ أَقَامَ الْخَارِجُ وَصَاحِبُ الْيَدِ كُلُّ وَاحِدٍ مِنْهُ بَيِّنَةً بِالنِّتَاجِ. Now it's the same kind of case, but the claim is regarding an offspring, a baby goat, a baby horse, a baby animal, right? Of some good pedigree or something, that, oh, this was born by me, and the other one is saying, no, it was born when it was in my possession, right? They both have evidence, and this is regardless of whether they've got no date or they've got a date, right? So this is the case where they've got no date or they've got the same date, both of them, right? Not in the case where they've got a different date. We're not discussing that yet. We're just discussing when they got the same date or no date. Then obviously the one with the possession in this case takes precedence, as we mentioned, that the person in the case where it's to do with offspring usually is going to take precedence, because because they're both providing evidence, they both are equal, but the fact that this guy is claiming that this is mine based on it being born by me, that and he has possession, that possession in that case adds to it. So the only time possession doesn't add anything to it is where it's just a normal claim of this is mine. And that's not the case here. This is a case of it is mine because it was born by me, right? وكذلك النسج في الثياب التي لا تنسج إلا مرة واحدة. The same is going to be the ruling. The same ruling it will be in the case of a piece that is woven, right? A woven piece, like something specially embroidered or woven, right? Clothing, an article of clothing that is uniquely woven, right? And something that can only be produced like uniquely once. So in that case, it will be the preference, and they both provide evidence, then it will be the person who has the possession. They will get precedence because they're adding something extra that they've got. The fact that they've got it in their hand show that they must be right in this case. So having something in your possession doesn't always show, but in many cases it does show and demonstrate that it must be yours because you have it, right? وَكَذَا كُلُّ سَبَبٍ فِي الْمِلْكِ لَا يَتَكَرَّرُ. Likewise, in any ownership of something that has a cause that doesn't replicate itself, right? That is only done once. For example, spinning cotton. Once you've spun that cotton, you don't do it again. So if there's two claimants that spun cotton is person A and person B saying the same thing, but person B has the possession, it will become his because he's laying claim to the reasoning as well of how he got it. Likewise, this milk is mine. No, not this milk is mine, because that would just become a default case of it's mine, right? Then the person who actually possesses it doesn't get preference in that case, the other one does. But it's like, I was the one who milked this from this cow. That's why it's mine. I milked it from my cow, right? Likewise, the case of shearing wool. I sheared it from this sheep, for example, and similar things like that. Because all of those are very similar to the original case of this was born from as an offspring from this animal by me. However, if it's something that can be done and redone, like construction of something that can be taken apart and done again, right? Then in that case, the person with the possession doesn't get preference because it could have just been disassembled and then reassembled again, right? And likewise, the case of just sowing something in the ground, like plants or crops, because again, that could just be done again. So in all of those cases, the precedence will be with the person who doesn't have it in their possession. It's interesting, right? Because these are things that can be overdone. So it just proves that the person in the possession just shows default. The other person, his evidence will show additional. So that's why he will get it. And if it's too difficult to decide, if it's something that can be done over and over again, or it's a unique action, and we're not sure, then you ask the people of experience, the people of that field, for a preference, that what case, this particular scenario, which one is it? Is it unique, or is it something that can be repeated over and over again? And if and then whatever they prefer, that it will go to that person. And if they find it difficult as well, then in this case you'll just go with the person who doesn't have the possession, right? That's what they say, were قُضِيَ لَهُ قُضِيَ بِهِ لِلْخَارِجِ, not the person in possession, the other person. Okay, next issue is, if the person who doesn't have possession but is making the claim and he provides proof as well upon just general ownership without saying where he got it from, and the person with possession is also providing evidence that he bought it from him. So person A is saying it's mine, not where he got it from, just that it's mine. It's mine. Person B is saying, I bought it from you. That's why it's mine now. And I have the possession of it. Now that works out perfectly. It was the first person, he has no date, right? And even if he had a date, the person is saying, unless he said, I bought it, it's mine. Actually, no, he just says it's mine, right? So that's possible that it could have been his, but then he sold it to this guy and he's just refusing. So really it becomes a case of person B saying, I bought it off you, and person saying, I didn't sell it to you. But person B has evidence to show that he sold it. Person B does not have evidence to say that I did not sell it, because you can't have evidence of not selling something. How do you have evidence that I did not sell this? How do you have evidence of that? Right? He only has evidence that it was mine. Okay, it was yours, but person B then bought it from you. Look at this, is his proof. He's got the documentation. He's got these witnesses. So it all works out. That's why the person and he has possession on top of it. Person B had possession of it. So possession, the person with the possession, he takes precedence, because he's proven that he bought it, he received the ownership from person A, and it all works out. Okay. وَإِنْ أَقَامَ كُلُّ وَاحِدٍ مِنْهُ الْبَيِّنَةَ عَلَى الشِّرَاءِ مِنْ الْآخَرِ. Now this is a case where person A is providing evidence, claiming, and then providing evidence that he bought it from person B. And person B is claiming that he bought it from person A, and he's also got proof as well. But they have no date to show which is which, because if they had dates, then obviously this person sold it to him, then this person sold it to him. It could be like that. So in this case, there's no way to give preference. They both are showing that I bought it from one another. We don't have dates to decide though, to give preference. تَهَاتَرَتِ الْبَيِّنَتَانِ. In this case, both of these proofs cancel each other out. So it goes back to neutral. Who gets it then? Then at least the person who's got possession of it has something going for him. So he will get it. He keeps it, essentially. This is according to, again, Shaykhain, Imam Abu Hanifa, Imam Abu Yusuf. Imam Muhammad says that no, we are going to take the two evidences, and in this case they both become it goes back to the issue of the person who they're just claiming ownership, because the fact that I bought it from you, you bought it from me, ultimately just saying that I bought it. They both have evidence. So the person who has possession of it is not establishing anything new. The person who doesn't have ownership, he is the one who's establishing with his evidence that I've got this is mine, and I have to take it of him because I bought it later. Maybe that it shows that I bought it later because he has it in his possession. So the person without the possession, he keeps it. It goes back to that view. That's Imam Muhammad's view. However, the critical scholars, they've gone with Shaykhain's opinion on this case, that you give it to the person with possession. Okay. We will move on to the next one. Okay, so in this case now, one person A brings his two witnesses. Person B brings four witnesses. Does that make a difference? 3, 4, 5, whatever, right? He brings more witnesses. Does more witnesses after you've reached the minimum, does it make a difference? That's what we're discussing here. So وَإِنْ أَقَامَ أَحَدُ الْمُدَّعِيَيْنِ شَاهِدَيْنِ وَأَقَامَ الْآخَرْ أَرْبَعَةً أَوْ أَكْثَرَ فَهُمَا سَوَاء. They're both the same. We don't look at who's got more. Once you've met the minimum amount, then it doesn't matter how many more it is. You're both going to be treated the same, because as soon as you got two men, or you've got one woman and one man and two women, it's like you've got the complete proof. So having any more doesn't really add to it in this case. Okay, so they both treated the same. Now you're going to have to look for another factor to give precedence between them. So if it's a case of just ownership, then it's going to be the person who doesn't have possession. If it's not the case of just ownership, but rather ownership based on a reason that I got it from here, based on this purchase, then it's going to be for the one who has the possession, as we mentioned earlier, right? Right. Likewise, let's just say that some of the, as long as they both have two each, and they both have been considered to be just and decent and upright, then it doesn't matter if one is like a major scholar or really pious and the other person is not as pious as that one. As long as they meet the basic criteria, then they become equal. Even if one is more, you can say, even if one is known to be even more just somehow, makes no difference afterwards. La ilaha illallah. Now we're moving into a claim of damage or wound or blood, would you call it, some kind of injury, right, or killing or murder, right? We're moving into those kind of cases where it's not just about he owes me this or that. وَمَنِ ادَّعَى قِصَاصًا عَلَى غَيْرِهِ. Anybody who claims qisas, which means a certain form of physical, physical transgression, physical injury, physical murder upon somebody else, and the other person is saying, no, I didn't do that to you. أُسْتُحْلِفَ بِاللَّهِ. What happens in that case? So the second person refuses. Obviously person B says no, the defendant refuses. أُسْتُحْلِفَ بِاللَّهِ. He will be made to take an oath. إِجْمَعًا. Because he's munkir. He is refusing, so he takes an oath. Now, فَإِن نَكَلَ عَنِ الْيَمِينِ فِيمَا دُونَ النَّفْسِ. If this is a case that is not about murder, but rather about an aggression of breaking somebody's hand, amputating cutting off somebody's finger, right, causing amputation of the foot, something of that nature, something lesser than the full life, right, the full, lesser than that, then in that case it's going to be فَإِن نَكَلَ عَنِ الْيَمِينِ فِيمَا دُونَ النَّفْسِ لَزِمَهُ الْقِصَاص. As soon as he refuses to take the oath, the qisas will be wajib on the person, right? The qisas will be wajib on the person, which means that he will have to pay, right? That's what it's going to be. So don't get confused here that when we said earlier that in hudud you're never told to take an oath. This is not had, right? This is qisas. Had is somebody's caught drinking, if somebody is caught committing fornication, and then there's a certain had for that. This is more about qisas, which is where there's a retaliation given based on whatever was originally committed. So if it's anything to do with limbs, anything less than a full life, then the oath will be taken in that case. If the guy refuses to take an oath, he will have to pay the qisas. Now on the other hand, if it's the case of a murder, a full murder, and he refuses to take the oath to say, no, I did not murder him, he refuses to do that, he just said, no, I'm not going to take an oath, hubisa. In this case, you can't kill him for that, because there's doubt, right? There's doubt. That's the full penalty. So you can't apply a penalty on him because of his refusal to say that I did not kill him. However, what they say is hubisa hatta yuqir. He will be imprisoned until he is able to either provide evidence or confess that yes, I did kill him, or takes an oath. So you're going to put him into prison, saying either take an oath that I did not kill him so that we can throw this case out, because why would you not take an oath? So then confess. But you're going to have to do one or the other. This is a serious case. It's not the case of just owing somebody a laptop or a pen or 20 pounds or 1,000 pounds or even 50,000 pounds. This is a life, right? So in the case of a life, you're either going to have to take the oath, or you're going to be in prison until you confess or take the oath. So this is a very, very serious case. Okay? وهذا, this is according to Imam Abu Hanifa, because he says that if he has his reasons, لأن النقول عنده بذل معنى, because he's saying that if he refuses, then it's like he is just relinquishing. And he's saying that when it comes to anything besides the life itself, you can treat that as like monetary things, right? But you can't treat you can't treat the whole life like that, right? It's not something you can give up like that. Sahibain look at it differently. If he refuses to take an oath, then while you can't consider him fully guilty and take his life for it, but just by refusal, يَلْزَمُهُ الْأَرْشُ فِيهِمَا. They look at both the cases, whether it's about a limb or the life itself. They say that he'll have to pay a compensation in both cases, both for the whole life and that he'll have to pay because according to them, right, according to them, لأن النقول عندهما إقرار فيه شبهة. Because remember, they take this as a confession. If they refuse to take an oath, they treat it as he's confessing to guilt, right? So although it's a confession, but because it's not a clear confession, it's not 100% confession. There's a doubt in there, and there's no way you can establish a full retaliation of a life for a life. Yeah, if he had confessed, you would take his life, right? In an Islamic state, you would take his life. But in a case where you're doing something else which is seen as a confession, there's a doubt in there. It's not fully a confession. So they said, you're going to pay a compensation. There's going to be a monetary compensation you'll have to pay. Okay, next case is about the claimant. This is not necessarily about two claimants anymore. It's going back to a single claimant. I don't know why he actually jumped into the double claimant. I think he should have dealt with all of the cases of the single claimant, the various different scenarios in that, and then he should have jumped into the double claimant. He's gone into the double claimant, I think, a bit too early. But anyway, we take it as it is. وَإِذَا قَالَ الْمُدَّعِي لِي بَيِّنَةٌ حَاضِرَةٌ فِي الْمِصْرِ قِيلَ لِخَصْمِهِ أَعْطِهِ كَفِيلًا بِنَفْسِكَ ثَلَاثَةَ أَيَّامٍ. So the case is brought into court. It's the date. So person A, who's the claimant, is there. Person B, the defendant, is there as well. Now, person A is asked for the proof, and he says, look, I've got, before even the proceedings begin, he says, look, I've got my evidence. They're in town, but it's just going to take me, some hours, or tomorrow. They can't come today, for example. They can come tomorrow. Now, what he's worried about is that person B is going to abscond somewhere. His opponent is going to abscond somewhere. So in this case, this is a special case scenario that to wait until tomorrow, he's given 3 days, right? Next day or the day after, I'm going to bring my witnesses. I don't trust this guy. So I want him to give me a guarantor for himself for up to 3 days. So provide me something as a guarantor that he is not going to abscond, so I can get my right of him, because I've got my witnesses. They just can't be present today. So for his security, because it all seems to be falling, in place, he can demand a guarantor for the other person. They do that. It's a bail, essentially. Nowadays, you can give a bail that the date is set for later, so you can go out, but give us a ransom. Sorry, give us a guarantor until then, just so that the person doesn't disappear and this person A's right is not then not achieved by him. So it's permissible in that sense. The 3 days, this is what Imam Abu Hanifa says, you can do it this maximum 3 days bail. You can do this no longer, right? And this doesn't make a difference whether this person is well known or not well known, whether he's wealthy, whether he's not wealthy. The same can be demanded of any of them, right? Then he says that فَإِنْ فَعَلَ, if the person provides a guarantee, a bail, he puts up a bail, provides another person in place of him or whatever it is, then great, alhamdulillah, no problem. وَإِلَّا أُمِرَ بِمُلَازَمَتِهِ. Now if the person does not provide, the defendant, the opponent, the adversary does not provide anything, then it's going to be said to the claimant that, look, you're going to have to stay close to him. You're going to have to literally stick to him. You're going to have to mulazamatihi, umira bi mulazamati. He's going to be commanded that, look, if you want your right, you're going to have to stay with him so that he's around. He doesn't go around. So maybe take a few people with you and just stay around with him, stay around his house or whatever it is, just so that your right does not get missed. إلا أن يكون المدعى عليه غريبا مسافرا على الطريق فيلازمه مقدار مجلس القاضي فقط. Now, This is if the person B, the defendant, was a local. If the person is not a local but he is actually a traveler who's just visiting town for a while, then you can't keep him back for 3 days, right? That person can only then be kept back until the end of the Qadi's session, right? Until the judicial session, right? So in that case, he won't give a guarantor. He'll just have to stay there until the end of the session, right? And this person will probably have to get the witnesses sooner than later, right? Because for a traveler, they, in those days especially, there may be a caravan that's leaving, and if he misses that, then there's not another one for 2 months, because you didn't have, 5 flights a day to certain places or whatever it is, or even 1 flight a day in those cases, right? This was about having multiple people come together, and a whole caravan would take place in those days. Nowadays they might look at this a bit differently, but anyway, well, what the case here is that you can only keep him until the end, so you better bring the proof as soon as possible, because otherwise you're going to be putting too much. You're going to create, he hasn't even been proven to be guilty yet, and we can't harm him essentially by making him stay for 3 days and giving guarantee and so on. Okay, next case is, you've got إذا قال المدعى عليه, the defendant, saying أودعنيه فلان الغائب هذا الشيء so person A is claiming against person B is the defendant. So person A is claiming that person B owns person A something. Person B says, actually, you know what? It's not yours. Person C has given me this, deposited this with me to look after, for safekeeping. So now you're introducing a third person here. He's saying, I know it's person D, the defendant is saying, I know it's not mine, but it's not yours either. Well, I can't say it's yours or not. Person C is the one who gave it to me for safekeeping. You did not give it to me. I didn't take it from you. Or he says he lent it to me. Or he rented it to me. So I've hired it from him. Or he says that he's given it to me as a collateral for some debt that I gave him. Or another one, I usurped it from him. I inappropriated it from him, not from you, right? And he provides evidence for that, right? فَلَا خُصُومَةَ بَيْنَهُ وَبَيْنَ الْمُدَّعِي. That means there is no, that means there can't be a case between person A and B anymore, because person A is claiming that person B, whatever he has, is person A's. Person B is saying, it's not, I don't know it's yours or not. I got it from person C, and he's got proof to show that he got it somehow from person C. So what should person A do? They should go and chase person A and person A, the claimant, should actually now put in a case against person C rather than person B, because person B is saying, it's not yours. I got it from this person, and this is the proof that I have. There's proof for that. Of course, if person A has proof against person C, that's different, right? But there is no proof there. There is no proof. Person A doesn't have any proof. But person B has proof he got it from somebody else. So now person A should go and put a case against person C, right? La ilaha illallah. Because he's basically proven that my possession of it is, I'm not your opponent. I didn't even take it from you. I don't even know you, for example. Imam Abu Yusuf says that if this person is righteous, then yeah, this is the case. There is no case. But if this guy is known to use a lot of trickery and deceit, and he could even make up stuff and get witnesses and so on, then this case will continue, because there must be some problem here, so the case can continue in this case. Now, this is a bit of a contentious issue, and there's about 5 opinions in this regard, and there's 5 ways of looking at it. So you can look into the books. They call this the Muhammasa. This is the 5-faceted issue, right? Anyway, let's move on. وَإِنْ قَالَ إِبْتَعْتُهُ مِنَ الْغَائِبِ فَهُوَ خَصْمٌ. Now, on the other hand, if this person B, rather than saying I borrowed it or rented it or it was given to me to look after or I usurped it, if he said instead that I purchased it, right? I bought it, I purchased it from that third person, person C, then in this case, this is a correct claim. He becomes the adversary in this case. Not person C, person B remains the adversary. He becomes an adversary. So the case is, because what he's done in this case, in all the previous cases, he proved that his possession of it was not of ownership. It was of borrowing or lending or safekeeping. So it's not really his. He's saying it's not mine. I'm not even claiming my right to it. Right? But in the case where he says I bought it from that person, person C or whoever it was, he's claiming that it's mine now. So there is a case. Because person A is claiming it's his and person B is claiming it's his. So there's a case. Now it has to carry on. Right? Because they're both claiming ownership. So that's what made the previous case separate, because person B said, I'm not even claiming ownership. It's not mine. Go and chase him. وَإِنْ قَالَ الْمُدَّعِي سُرِقَ مِنِّي. Now, if the case is such that person A is saying, this is my item and it was stolen from me. He didn't say who stole it. He just said it was stolen from me. He kept it vague in the third person. It was stolen from me. And he provided evidence that it was his and it was stolen from him. Right? And the person who's holding on to it, who's possessing it, whose the claim is against, he's saying, look, I know it's not mine, but I was given it as safekeeping by person C. And he provides evidence for that. Now in this case, there is still a case. He can't repel the case by saying that in this case. According to Imam Yusuf and Imam Abu Hanifa, rahimahumullah. This is the istihsan. This is the juridical preference. The default is that this would throw out the case, just like the previous case. It was thrown out when he claimed that he didn't own it. He was just holding on to it somehow, right? Due to a reason. That Imam Muhammad goes with that. Imam Muhammad says that no, the default in this case is just like the other case where the case will be thrown out, because he is not claiming anything on it. He's just saying that I'm holding on to it, right? So it's just like, in fact, he looks at it differently. He's saying that, you know, person A, what is his claim? His claim is it was stolen from me. He doesn't say who stole it. He's not charging the other person for stealing it. He's not saying he stole it. He's just saying it was stolen from me. He's not willing to say he stole it. If he said that he stole it, that would be a case. Because he's charging him with something. He's just saying this thing is mine, it was stolen from me. He's not saying who stole it, so it could be that that third person stole it. So go and chase him then, right? That's what Imam Muhammad, he looks at it like that. So the Shaykhain though, they're saying that look, the fact that he said it was stolen from me, he wants to keep it purposely vague, but obviously somebody stole it. And it seems like the person who's possessing, person B, who it's in his possession, he's probably the one who's stolen it. Like, it's possible, right? If this guy is saying what's right, then it's likely that that person B has stolen it. Not person C, person B has. Except that person A is not willing to charge him, because if he charges him with stealing, that becomes a different case. It becomes a state case of theft. And in the case of theft, hands are cut off. So he doesn't want that to happen. He just wants his item back. That's why he's keeping it vague purposely. They're looking at this very deeply, right? He wants to be compassionate. He doesn't want his hands to be cut off. He just wants his property back. He wants to, also, there's a responsibility of, keeping people veiled. So he doesn't want to do that in those kind of cases, you know, that are state cases. You'd rather keep people veiled, right? So it's like he's saying it was stolen from me. And so that's why it's thrown out of case. If he's not willing to say it clearly, then they're saying that there is there is still a case and there's a reason. So Imam Muhammad says there's no case anymore. Whereas Shaykhain, they say it is a case, and he's just trying to not make it a case of theft. Because if that gets proven, the other person's hands will be cut off. So he doesn't want to make that charge. but he wants his item back, so we're going to have to let this proceed and let it play out, right? This is, this is different to, for example, saying that it was usurped from me, right? In that case, there's no penalty for that as such, except just a liability claim, right? So in that case, it would be different, but he's actually saying it was stolen from me. So that's why we're going to have to take this more seriously. Isbi Jabi says that Sahibain's view, Shaykhain's view, Imam Abu Hanifa and Yusuf, that is the istihsan view, and that is what will take precedence. Okay, to complete today's a few more issues that we have. وَإِذَا قَالَ الْمُدَّعِي ابْتَعْتُهُ مِنْ فُلَانٍ الْغَائِبِ. If the mudda'i, which means the claimant, says that I purchased it from person C, وَقَالَ صَاحِبُ الْيَدِ, and the person who's holding on to it, person B, the defendant, is saying, no, so-and-so has given it to me for safekeeping, سَقَطَتِ الْخُصُومَةِ عَنِ الْمُدَّعَ عَلَيْهِ بِغَيْرِ بَيِّنَةٍ. So this is interesting. The claimant is claiming that I purchased it from person C. Person B, who actually has it. So essentially, person A is saying, it's mine. I bought it from him, so it should be mine. But he's not saying that. He's just saying, I bought it from him. Person B is saying, the one he's got it in his possession, he's actually saying that person C or D or whatever it is, person C, actually person C himself, right? So the person A, person B, person C. Person A is claiming against person B, but he's just saying that I bought it of person C, so I should have this product. Person B is saying, oh, person C has just given it to me to look after. Well, there's no claim. There's no case. Fine. Go to person B, go to person C, the one you bought it off, that you're saying, because person B is not rejecting and denying that you bought it of person C. He's just saying that I can't give it to you because person C has given it to me to look after. So go and sort it out with person B and take it. I'm not claiming that it's mine, so you can't put your claim against me because I'm not saying that I own it. I'm just looking after it. So there's no claim. There's no case. سَقَطَتِ الْخُصُومَةِ, right? The dispute ends, it drops. عَنِ الْمُدَّعَ عَلَيْهِ, from the defendant. Starts another case on person C instead, right? بِغَيْرِ بَيِّنَةٍ. You don't even, need any evidence, because the guy's saying, yeah, look, I can agree, it might be yours, but I have just been told to look after it. لِتَصَادُقِهِمَا عَلَىٰ أَنَّ الْمِلْكَ لِغَيْرِ ذِي الْيَدِ. Because they both agree that person B doesn't own it, right? Whether person A owns it or person C owns it, that's besides the point, but at least person B doesn't own it, so you can't put a case against him, right? So yeah, so now you can understand how these things are working now, right? Hopefully this gives you an idea of how these things work, and as I said, we can actually use this, right? We can actually use this in our cases that we might have to deal with in our family or friends or whatever. This is the way to deal with it. Okay, there are some nuanced differences in some of these, otherwise basically it's quite clear. There are some cases of the al-milk al-mutlaq and the non-milk al-mutlaq, the qualified ownership and so on, but otherwise it's pretty straightforward, right? So jazakallah khairan, and please keep us in your prayers. May Allah subhanahu wa ta'ala bless you all. We'll see you in the next lesson inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.